Good day, Crime Talk aficionados. We have a great show for you for the last day of the year. First, we clear up some incorrect statements in the Luigi Mangione case about the federal judge and her husband that was a pharmaceutical executive. Bryan Kohberger's attorneys want the prosecutor's sanction for not disclosing expert reports for their 25 experts. The Castle Doctrine is alive and well in Florida. We have this day in legal history and our dumb criminal of the day. Let's talk about it.
Lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below and hit that little bell for notifications. And yes, you can check us out on any of your favorite podcasting apps as well. Before we get to the show, though, please go to crimetalksearch.com. Get there before the end of the year, and you'll be able to do as many background searches on anyone here in the United States that your heart desires. Anyone you're maybe just curious about, maybe somebody coming into your life, maybe somebody leaving your life that you think maybe the wheels have completely fallen off and you're just curious. Go to crimetalksearch.com, sign up for that background subscription service today. And like I said, you'll be able to do a background search, have it emailed to you literally while you wait. So whether you're curious or you really need to know, go to crimetalksearch.com. All right, ladies and gentlemen, it is December 31st, 2024, the last Crime Talk show for 2024. We're going to come back big and bold next year for 2025. A lot of big events. Just me personally, I got a notification from YouTube the other day that said this was my 7th year from starting a channel. We didn't really get going, I think, until about year, 6. But also, it is my 30th year practicing law, being a licensed attorney, and my 25th year for having my own law practice. So 2025 is a big year, ladies and gentlemen, and thanks for joining us, and we look forward to the future as well. And a quick note, we will not be here tomorrow in person, but have we got a treat for you? That's right. We've got a recap of the dumb criminals of the day throughout the year. It's kind of a best of show. So hope you enjoy it and come check it out. All right, first on the docket, Luigi Mangione. That's right. The man accused of fatally shooting the United Healthcare CEO, Brian Thompson, obviously is facing both state and federal charges. The federal charges are murder and stalking, and the state charges are murder and terror charges in New York, and he's got some charges in Pennsylvania where he was arrested back on December 9th. Now, people on social media have claimed that the judge presiding over Mangione's case is married to a former executive at the pharmaceutical company Pfizer. People are suggesting that that's a conflict of interest. Well, let's break it down and find out why that is a myth. So the judge for Luigi Mangione's case is married to a former healthcare executive and has millions of dollars of stock in the healthcare industry, which was going around on social posts. Well, the post suggests that this judge will also be presiding over the Mangione trial. So is the judge overseeing Luigi Mangione's case married to a former Pfizer executive? The answer is yes. There needs to be a little more context. First, the United States Magistrate, and that's key, Magistrate Judge Catherine H. Parker, who is married to a former Pfizer executive, is overseeing Mangione's pretrial hearings in the federal case. But she's not going to oversee his federal criminal trial. Now, Parker will also not oversee any of Mangione's criminal trials at the state level either, because it's in the federal court system. And because magistrate judges like Parker can oversee some matters in felony cases like Mangione, such as deciding whether to set bail or a pretrial detention before they go to trial, their role is very limited. They do not oversee, as magistrates, felony trials. That's the judge of a district court judge. And Mangione appeared before Magistrate Judge Kramer Parker in Manhattan Federal Court back on December 19th. Now, the claims about Parker's connection to Pfizer stem from a report published by a journalist by the name of Ken Klippenstein's Substack back on December of this year, December 23 of this year. And in that report, it says that the judge who is married to Brett Parker, who left Pfizer in 2010, 15 years ago now, after serving as vice president and assistant general counsel at the pharmaceutical company. And on Brett Parker's LinkedIn page, it confirms that he worked for Pfizer until 2010. He currently serves as the executive director of the New York City Bar Association. Now, contrary to what was on the viral online claim, it appears to suggest Judge Catherine Parker won't preside over Mangione's federal criminal trial at all. That's because there are, like I said, different types of federal judges who have different responsibilities. In criminal cases, magistrates, like Judge Parker, conduct preliminary court proceedings, such as initial appearances and arraignment, when a defendant is brought before the court to hear the charges against them, usually at first advisement. But a magistrate judge cannot be in charge of the felony criminal trial. Although magistrate judges cannot preside over felony criminal trials, they can dispose of only petty offenses and misdemeanor cases. They can conduct preliminary hearings and post-conviction proceedings in felony cases. District court judges are the only ones who hear felony trials. Now, in the selection process for a district or a magistrate judge is also different. Under the United States Constitution, district court judges are nominated by the president and confirmed by the United States Senate. Magistrate judges, however, on the other hand, are appointed by a majority vote of all of the active district court judges because they have to work with them, and they do a lot of work on the civil side for the district court judges that the district court judges just don't want to have to deal with. Now, if Mangione's federal case goes to trial, who will be presiding over it? Well, it's still a little unclear. As of right now, Mangione is scheduled to appear in federal court again on January 18th. Now, also because of Luigi Mangione, prison consultants are big in the news these days. And apparently, Luigi Mangione has retained Harvey Weinstein's prison consultant, a guy by the name of Craig Rothfeld. Now, Rothfeld previously spent time in prison for white-collar crimes and has now become a top prison consultant. Now, in an interview that he did back in 2020, he told NBC of his clients, "Often I tell people you are going into a Byzantine black hole." Rothfeld said that of the disgraced movie mogul after he was convicted of felony sex crimes, "I'm talking to him about the first 90 days. They're very dark. They're very uncomfortable because you're on buses, you're in handcuffs, you're in leg shackles. You can't get packages. It is just scary." What it will be like for him is you are completely powerless. Now, there's also another consultant out there, a guy by the name of Larry Levine, shared how he believes the situation will unfold for the 26-year-old Mr. Mangione. Levine, who served 10 years in prison, stated that he'll never be found guilty, referring to Luigi Mangione. Because who uses the healthcare system? Well, older people. Who gets turned down for procedures and healthcare, primary care? Older people. Who primarily sits on a jury? Older people. This guy says that it's no longer about Luigi and what he did. It's about the healthcare system. Retirees are less likely to have a valid excuse, such as employment or child care responsibilities, to get them off of jury duty. So Levine predicts that the prosecutors will waste years trying to convict Mangione, but in the end, he will be found not guilty by reason of insanity. Would a normal person have done that? No. So he's really cuckoo, according to this Levine guy. So what they'll do is they'll find him not guilty by reason of insanity. Then they'll do something called a civil commitment, he said. Anyway, I could not disagree more. I really don't think there's going to be a mental health defense here. I think you got to go for the whole enchilada. You got to go big. And if you saw our show yesterday, you know we got to go ID. We got to say that's not the Mangione, right? You want to do a combination of a little bit of jury nullification, because you can't just say, find him not guilty because you like what he did. Murder's wrong. So you have to give an excuse and say, well, they've raised reasonable doubt. I'm just not sure that that's him. He was in a mask. It doesn't look like the same people from those photographs and what Mr. Mangione looks like when he was there. All the other stuff, you can explain it away. Oh, you found this on there? Well, did he write it? Do you know who did you test for handwriting? All the other items, was there somebody else that had access to this firearm? Who had he met with beforehand? You got to set it up that he was basically framed, something along those lines, which you can make it out to be plausible to raise reasonable doubt for Mr. Mangione. Now, don't get me wrong. Murder is always wrong unless it's legally justified, or the prosecution has failed to prove their case beyond a reasonable doubt. Just something to think about, ladies and gentlemen. Next, the Bryan Kohberger matter. The attorneys prosecuting the case against Bryan Kohberger, obviously the man charged of murder in the deaths of 4 University of Idaho students, have settled on their group of expert witnesses for next summer's trial. Now, the lead prosecutor there is Bill Thompson, and the prosecution met a court-imposed deadline to submit a list of those experts and their credentials last week. But the identities of those included among the group intends to call as a witness in the case against the defendant Bryan Kohberger is being kept from the public, which I think is ridiculous. Anyway, the Ada County District Judge, Stephen Hippler, had pushed back several deadlines, including the trial start date, after he took over the high-profile murder case when it moved out of Moscow to Boise at the defense request. Now, Judge Hippler gave prosecutors an extra 2 weeks to settle on their group of experts before they had to turn over their list of experts to the defense. Now, under this agreement to seal between the defense and the prosecution, the state's expert list was filed through the legal process known as discovery on December 18th, according to publicly available records. Now, Hippler's case scheduling order did not require the expert list to be filed under seal, but he also has not unsealed the filing for public consumption. Now, on Friday, Kohberger's defense team filed a motion with the court to compel the prosecution to provide written summaries for the testimony of his expert witness, the case summary showed. Now, the filing also includes a request for the court's sanctions. Now, late next month, the defense must provide the state with its own group of experts for the trial, which is scheduled to start in August of 2025. Deadlines are also in place into the spring for both to disclose their witnesses during their cases in rebuttal and the possible sentencing phase if Bryan Kohberger is found guilty. Now, in late April of next year, the defense and prosecution must each file with the court the names of people they separately plan to call as non-expert lay witnesses. Who are those people, how they can testify, and the facts from their personal experiences. The judge ordered those lists to be sealed, and we'll have to wait and see if those are unsealed at any given time. Now, like I said, for those who are not familiar with the case, Kohberger is accused of the November 2022 fatal stabbing deaths of 4 University of Idaho students at the off-campus home on King Road there in Moscow, Idaho. The victims were Madison Mogan, Kaylee Gonsalve, Zaina Kernodle, Ethan Chapin. Now, after a manhunt lasted nearly 7 weeks, Kohberger was arrested in Pennsylvania in December of 2022, and he's charged with 5 felonies, 4 counts of murder, and 1 count of burglary. Prosecutors intend to seek the death penalty if the jury is convicted. Now, a lot of those lay expert witnesses will more than likely come from the police department as well as from the FBI. Basically, they're non-retained experts. They're experts based upon their training and experience, and they can testify to things. And they have to be an expert if they provide something that's not basically known to everybody, common knowledge, so to speak. Now, we know the defense is probably going to call Cy Ray, a cell phone tower data expert and a former police officer in Arizona, and it's anticipated to be a witness to challenge the cell phone evidence that allegedly links Kohberger to being in the area at the time of the morning murders. His attorneys have already had Ray testify at a pretrial hearing back in May, and lay witnesses at trial are expected to include 2 roommates at the King Road home who went physically unharmed back in November of 2022. Now, each sat for numerous interviews with the police, according to the arrest affidavit, and they helped investigators establish the 4 victims' whereabouts during the night of their deaths, with one of them providing eyewitness details about a masked man with bushy eyebrows in the home around the time of the suspected deaths. Now, as I noted, the defense has filed a motion to compel, and sometimes you just got to read the whole motion just because it kind of gives a little more context. And this was filed just a few days ago, and the motion is motion to compel in accordance with the Idaho Criminal Rules 16b7 materials and request for sanctions. Comes now Bryan Kohberger by and through his attorneys of record, and hereby move this honorable court for an order to compel complete expert disclosures from the state in this matter and request sanctions pursuant to ICR 16K. The bulk of the state's expert disclosures fail to include opinions and reports. These inadequate disclosures greatly prejudice Mr. Kohberger, who is obligated to submit defense guilt phase expert disclosures by January 23 of 2025. The sanctions considered must be the exclusion of the experts or at a bare minimum an order compelling proper disclosure and an extension of Mr. Kohberger's January 23, 2025 deadline. And there's a little footnote here. It says Mr. Kohberger does not include here a motion to strike the death penalty for failure to properly disclose experts. Without proper disclosures, that motion is forthcoming. Kind of like what happened in the Lori Vallow case, where the prosecution failed to turn over evidence in a timely manner, and the judge, as a sanction, removed the death penalty as an option for the people in that case. Anyway, the motion continues. Mr. Kohberger is prejudiced because he does not know what expert evidence the state intends to elicit. He does not know what expert evidence he must confront. Then they go on to the relevant facts sections. In this case, there are over 68 terabytes of discovery produced in a method that the defense has repeatedly referenced in pleadings and at various motions hearings as extremely disorganized. There have been 20 specific requests for discovery and 6 motions to compel filed by the defense. The court entered a redacted order governing further criminal proceedings and notices of trial setting on October 9th of 2024 and has notified the parties that strict compliance with the court order is expected. On December 18th, 2024, the state disclosed 25 experts. Of those, only 5 include actual expert reports. Notably, not a single DNA expert opinion or report was produced. Instead, the state's disclosure refers to Bates numbers, pages, and say, quote, "This disclosure is provided as an aid. It does not encompass all findings, impressions, conclusions, or materials related to the expert's involvement in this case. It further does not in any way limit the scope of the expert's testimony. Further, this expert may testify about findings, impressions, and or conclusions that she drew from the work of other experts who previously examined or handled the evidence in question," end quote. At least 3 digital forensic experts are disclosed with lists of 67 electronic devices or third-party database examined. Not a single report of what the 3 experts will opine relate to any specific device or data is disclosed. This is a capital murder case, and nothing about it is clear-cut. The expert issues are complex, involving many different facets of DNA, cellular data, cell tower coverage and drive testing, car identification, crime scene and blood splatter analysis, fingerprint analysis, forensic pathology, and electronic device analysis of the suspect, victims and alternative suspects, and social media accounts. At issue in the state's supplemental response to requests for discovery regarding expert testimony and its exhibits, filed December 18th of 2024. The disclosure lists 25 experts and provides curriculum vitae, 5 with expert opinion reports, and others with reference to Bates numbers or items, but no opinion data or methodology. What's the state's disclosure doesn't follow the rule, which states expert witnesses. On written request of the defendant, the prosecutor must provide a written summary or report of any testimony that the state intends to introduce at trial or at a hearing pursuant to Rule 702, 703, or 705 of the Idaho Rules of Evidence. The summary provided must describe the witness's opinions, the facts and data for those opinions, and the witness's qualifications. Disclosure of expert opinions regarding mental health must also comply with the requirements of Idaho Code Section 18-207. The prosecution is not required to produce any materials not subject to disclosure under subsection G of this rule. This subsection does not require disclosure of expert witnesses, their opinions, the facts and data for those opinions, or other witnesses' qualifications intended only to rebut evidence or theories that have not been disclosed under this prior rule to trial. As the Court of Appeals held, the plain text of Rule 16b-7 requires the disclosure of expert witnesses' opinions, the facts and data of those opinions, and any testimony that the state intends to introduce pursuant to 702, 703, and 705 of the Idaho Rules of Evidence. That encompasses not only expert opinions, but also scientific, technical, and other specialized knowledge to which a qualified witness may testify in a form other than an opinion. As the court explained in Marin, the case that I just cited to, when an expert relies on some form of scientific or technical information, that must be disclosed, as opposed to other witnesses whose opinions may be the less scientific variety. The discovery rules are designed to safeguard the truth-seeking function of trials, promote fairness and candor, to facilitate fair and expedited pretrial fact-gathering, and to prevent surprise at trial. If the state violates a disclosure requirements under Idaho Criminal Rules 16b-6, the trial court has considerable discretion to fashion an appropriate 16K remedy. Mr. Kohberger continues wading through a sea of discovery. The need for rule-compliant expert disclosures is critical to his ability to prepare for his defense at trial. The state's failure to comply is not harmless. Conclusion, Mr. Kohberger must be able to confront the evidence against him, and to do that, it must be disclosed in accordance with the Rule 16 in the court's trial setting order. The expert evidence disclosed by the state is woefully inadequate. This is a capital murder case, and compliance with the rules of discovery are not optional. Mr. Kohberger is prejudiced by the state's failure. It is impossible for him to confront unknown expert opinions with his own expert disclosures. Now, I'm going to agree with the defense on this particular rule. Nothing is more frustrating than the state says, here are your expert reports, here's the report. Well, that's not what Rule 16 provides. It says you need to give a report. And most judges say this is what they're going to testify to, and they don't get to stray from what's in that particular report. Now, here's the thing. It is a death penalty case. So is the judge going to strike the prosecution from putting forward their case in chief because of these experts? Probably not. He may, at most, at a probably upcoming hearing, will tell the prosecution to comply with the rule, and he'll give them a free pass. And that's why they do this, because judges rarely ever hold the prosecution's feet to the fire when it comes to expert witness disclosures. In civil cases, they're a little more strict. Criminal, they're like, well, it's going to blow up their case, so let's not, deal with that. Anyway, prosecution, you need to comply. You have had now, we're going on 2 years, right? November of 2022, so we got 2023, 2024, we're going into 2025. 2 years that you could have had all of this done, and it should have been ready to go. Remember, when the prosecution brings charges, ladies and gentlemen, they're saying we are ready to try this case. And clearly, they have never been ready to try this case. We saw this in the Vallow case. We saw this in the Chad Daybell case. Prosecutions never prepared. They always disclose late, and they get a pass. It's not just an Idaho thing. It happens everywhere too frequently. Now, do I think the case against Kohberger is going to get dismissed because of this? No. Do I even think there's going to be sanctions against the prosecution? No, unfortunately not. We'll bring it to you as the information comes in, ladies and gentlemen. Next, in Florida, the Castle Doctrine is alive and well. A Florida sheriff delivered a very no-nonsense message after a homeowner fatally shot an armed intruder. The Manatee County Sheriff, a guy by the name of Rick Wells, was at a news conference after a shooting Thursday night after a confrontation that left one burglar dead and another one in custody. Now, the incident occurred around 9 p.m. when a homeowner spotted two masked men on his surveillance cameras. He told his wife to go to somewhere safe in the house, and he grabbed his gun. And guess what? That homeowner was able to shoot one of the suspects while the other one ran away, and he was later caught by police. Now, both suspects were revealed to be illegal, whose visas had expired. Now, this is the state of Florida, and if you want to break into someone's home, you should be expecting to be shot, said Sheriff Wells. The dead intruder was identified as Jorge Nesteves Flores Toledo from Mexico, who also went by Annabelle Miller Valencia. He was rushed to the Sarasota Memorial Hospital with multiple gunshot wounds, but died Friday morning. Now, the homeowner fired at least 3 shots, and the second suspect, who is identified as Mikel Sotomayor from Chile, he was found by the homeowner climbing into a window before backing away and running off. Now, police found him a couple of blocks from the homeowner's residence, and Sotomayor was arrested and charged with armed burglary. He's currently in custody, and more charges are coming. Sheriff Wells praised the victim's quick thinking actions. He knew something bad was about to happen, and he didn't stall. He grabbed his firearm, told his wife to get to a safe spot, he said. It's alive and well. Yes, ladies and gentlemen, check your local laws, but in most jurisdictions, if somebody comes into your home, you can potentially shoot them if you are in fear of death or serious bodily injury. Make sure they cross the plane, though. Plane of the house. Check your local, consult a local attorney to get sure legal advice, okay? Most states, though, don't shoot them on the porch. You can't drag them into the house. Once you shoot them on the porch, you got to break the plane. Remember that. And if you have certain detached garages, that's usually not covered as well. Just trying to make you safe out there. Next on the docket, this day in legal history, on December 31st, 1862, President Abraham Lincoln signed legislation creating the state of West Virginia. Now, the bill split the western section of Virginia from the rest of the state, which had left the Union to join the Confederacy. However, West Virginia was not granted formal statehood until legislation took effect on June 20th, 1863, after a statewide referendum was approved the legislation. Then, on this date in 1970, the legalization of gold ownership in the United States. Yes, ladies and gentlemen. So after being banned for private ownership since 1933, it was once again legal for U.S. citizens to own gold. Obviously, this affected financial regulations and individual investment rights, influencing economic and legal policies related to precious metals. And then we have Ted Bundy. On this date in 1977, Ted Bundy escaped from jail. That's right, he escaped from a jail in Colorado. They're in Aspen, Pitkin County, leading to a nationwide manhunt before his eventual recapture. Now, one of our first videos that we did in this years ago was I interviewed a friend of mine, a local attorney here in Colorado by the name of Chuck or Charles Leidner, who represented Ted Bundy up in Pitkin County. Had a great interview with him. Maybe we'll have Frank put a link to that interview, and somewhat interesting indeed. So, a little local twist. Anyway, like I said, Ted Bundy, obviously dead now, for convicted of being a serial killer there in Florida. Anyway, also on this date, December 31st, 1974, we had the Privacy Act of 1974 went into effect, establishing safeguards for personal information held by the federal government. And then on December 31st, 1999, the Panama Canal handover took place. That's right, control of the Panama Canal was officially transferred from the United States to Panama as stipulated by the 1977 Torrijos-Carter Treaty. Obviously, that was a significant moment in international law and treaty enforcement. And, of course, now it's a hot topic because the president said, by God, we're not going to have the Chinese running the Panama Canal, so maybe we'll take it back or try to figure out a way to take it back. I somehow think that would involve some armed intervention. I've been to the Panama Canal. It's actually quite impressive. But when I was there, it was like 8 years ago, they were actually building the bigger Panama Canal just south of that because the ships are so big, they can't get through the little Panama Canal. So it's interesting. Obviously, who knows what the heck's going to happen. And finally, our last dumb criminal of the day. That's right. A Jack in the Box customer got a beating after attacking restaurant staff for forgetting her curly fries. Now, this incident, which is believed to have occurred in Spartansburg, South Carolina, quickly escalated as the customer screamed at the staff for failing to add her 3 orders of curly fries to her combo meals. Who wouldn't be upset, right? Anyway, this video that was shared shows the woman yelling that she would, quote, blow this whole mother effing up if her order wasn't fixed. And you can see what happens from there. Food violence, ladies and gentlemen. I don't know. People get hangry and they want to start hurting people and they don't get their orders right. Anyway, just something to think about. That's all we have for you today. Last official show of the year. I hope you enjoyed it. Thanks for joining us. I hope you continue to join us in 2025. Tomorrow we'll have a show just on the best of dumb criminals of the day. We'll get that up early as well. Have a happy new year. I hope it all is safe and prosperous for everyone. We'll see you next year. And remember, the Constitution matters.